No, I images are and a few network are just showing, but it's repeating. But you got to it's repeating.
I'm already live already. I'm waiting for you to join. Good day, everyone.
Okay, I think I can bring the exact
Joshua, can you hear me now? Hey, I've seen you now.
Okay.
Thank you so much. It was a very beautiful
Finally,
process.
finally, it was entirely embarrassing. My apologies on a
Can you
serious
hear me?
note. Yes, I can hear you very well. Talk to me.
Can you hear me?
I can hear you perfectly well. Talk to me.
Okay, please, just 5 minutes for more persons to join. We are going to kickstart as soon as possible.
Okay.
Yeah, Mr. Benson, can you hear me?
Yes, of course. I can hear you perfectly well. Go on.
Please, can you just speak again?
I can hear you.
Okay, I want to believe the audience can hear you. Um, thank God, Joshua. Thank you for joining. You said no sound. I believe you can hear me now. So we have spent some time, trying to join in, while our guest was trying to join in. I want to welcome everyone to Nigerian Law Student tutorial platform. This is a platform where we educate law students on areas of law that they need to have knowledge on. We understand how it could be most times. We understand that at times, even what the lecturer has taught in class, may not be able to sync well with us. That's why we need someone like us, someone like who is like a colleague to us to explain some of these things. The more we keep explaining it, the more it keep going to our residual memory. So without wasting, so without spending much time, we would like to go straight into what we are here for. We're here to talk about the process of impeachment in accordance with the Constitution of Nigeria. The Constitution of Nigeria 1999 as amended. We're going to be looking at the process of impeachment according to the Constitution. And also in this discussion, we're not going to be ignorant of the happenings in our society. Therefore, in this conversation, in this live chat, we are going to be cross-matching the constitutional provision for impeachment and then issues arising with regards to this constitutional provision for impeachment, using Rivers State as a case study. I urge you to sit tight and stay to the end of this conversation. It's just going to be, it's going to last for not more than an hour. So I urge you all to sit tight, share this link so that your friends can join wherever they are. My name is Arinze Isdore. I'm a law graduate and also a constitutional and administrative law enthusiast. I'm an aspiring lawyer in that area of law. And this area quickened me to put up this live conversation. Please, if you're joining, we would like to know you. We would like you to comment and also do well to subscribe to this channel. Double tap to like if you enjoy what we're doing here. Do well to like as well. I have a guest with me tonight. His name is Benson Osaki. He is a law graduate, and when I mean a law graduate, a law graduate with a capital letter, and he is also constitutional and administrative law scholar, a scholar in it. So we are going to learn from one of the best brains. While we were in school, we used to refer to him as Ben Nwabueze. That's to show you his constitutional mind. And today he's going to unleash that mind for us. We're going to benefit from, we're going to tap from his wealth of knowledge in this webinar section. So I implore you to sit tight, invite your colleagues so that they can learn. So firstly, he's going to take us on meaning of impeachment and impeachment process with respect to the constitution and judicial provision. Thereafter, we'll look at some of the issues that are arising in the process of impeachment using River State as a case study. And thereafter, we're going to have a question and answer section, 15 minutes, for those participants who are in this live stream who have questions to ask. And thereafter, we'll come with the recommendation, which is the way forward. And then we're going to close this section. So thank you, audience. Thank you for joining. Mr. Benson, I would like to take over from here. Thank you all.
Thank you. And I also welcome all of you who are live on air.
Also,
I guess you can hear me from there.
yes, we can hear you.
Can you hear me from there?
Yes, we can hear you.
Okay, very well. Thank you. By way of preamble, the term impeachment was not particularly used by the 1999 Constitution as amended. However, legally, the term impeachment simply means the initiation of the process of unseating a governor or a deputy governor, as the case may be, or a president or the vice president. In the instant case, the governor and the deputy governor. Now, that's being established. Removal, it is the actual act of unseating a constitutionally elected governor or deputy governor or jointly, as the case may be. Having said that, the Constitution is the ground norm, it is the ultimate law, and every other law derives its validity from Constitution. That is largely because the State House of Assembly makes law. The National Assembly enacts an act or acts, as the case may be. But I will confine myself to that of the state because we are dealing with the state. Now, the Constitution has provided unambiguously, pursuant to Section 188, subsection 1 to sub 9, and by extension, sub 10 and sub 11. Now, I will take it sequentially. This relevant Constitution provides for the impeachment of a governor or that of a deputy governor. Now, it is to be commenced by 1/3 majority of the entire members of the House of Assembly. And it is going to be signed by the 1/3 majority and transmitted to the Speaker of the House of Assembly, who is expected by pursuant in virtue of the provision of the Constitution to transmit within 1 week, 7 days, occupier of such office that is affected by such allegation. And it should also cause a copy to be transmitted to each member of the House of Assembly. No member shall be denied a copy of that notice of gross misconduct allegation. However, within 14 days, 2 weeks, as to whether the occupier of that office, that is to say the governor or the deputy governor, responds to the allegation or not, the Speaker is the assembly members are expected this time around, 2/3 majority of the entire House will also endorse for the formal investigation of the notice of allegation of gross misconduct. Upon that, the Speaker will the Chief Judge of the state, the Chief Law Officer of the state, and he is empowered by the Constitution to constitute 7-man committee, and who, in his opinion, are persons of unquestionable integrity, not in the opinion of any other person, in the opinion of the Chief Judge. And they are not persons who are political members, who are members of the National State House of Assembly, or any, they are independent persons. However, it is the State House of Assembly that is to set out the procedure for the investigation. The procedure for the investigation is the function of the House of Assembly. Now, when the panel of seven persons have been constituted by the Chief Judge, they are given a duration, a periodicity of 3 months, 90 days. Before the expiration of 90 days, they are expected to tender their report as to whether the accused person is indicted or otherwise exonerated from the purported allegation. Now, should it be that the report indicates that they are not implicated in the alleged gross misconduct, that is the end of the whole process. But in the event that the report indicates that they are implicit in the alleged gross misconduct, then within 2 weeks, 2/3 majority of the House will sign, and that will become the impeachment or the removal of the governor or the deputy governor, or both of them. It depends. However, sub 10 now establish alter clause depriving the court of exercising jurisdiction, of assuming jurisdiction, on the basis that that proceeding is a politically associated proceeding and it has nothing to do with. Sub 11 of Section 188 now define what is gross misconduct. Gross misconduct is defined as simply as the grave violation, the infraction of the Constitution, if you like, particularly with the relevant section of Section 188 as it pertains to that of the governor and deputy governor, Section 143 as it pertains to that of the president and the vice president. Now, that is a clear standpoint of the whole procedure. Now, one thing is paramount is that more often than not, we notice, by way of clarity, that the members of the River State House of Assembly, with particular reference to what is happening, they have always brandished arrogance of number as to what gives them the impetus to impeach a governor or the deputy governor. But critically looking at the provision, the extant provision, with particular reference to Section 188, sub 1 to 9, it is not just them that is involved in the impeachment or removal of the governor. Sub 5 made us realize of Section 188 that the Chief Justice of the Federation, of the state, I beg your pardon, with respect to states, is empowered by the Constitution to set up a panel, in his opinion, not in the opinion or in the estimation of any other person, but it's strictly in his opinion. And these persons are apolitical. These persons are not partisan. These persons are independent persons. And even though the procedure is set out for them by the State House of Assembly, they have independence to decide whether in their reports the governor is guilty of the allegation or not, or the deputy governor. That's been established. Now, prior to this trend, the position of the law is that the court is devoid of jurisdiction to entertain matter as it pertains to impeachment, pursuant to sub 10 of Section 188 that expressly excludes or prevent or preclude the court from exercising jurisdiction. There are plethora of judicial authorities, but with particular notorious case of Balarabe Musa against Kaduna State House of Assembly. The deceased governor then was in a minority party. The House of Assembly of Kaduna State was manned by opposition majority party. They frustrated all his attempts to screen and confirm commissioner nominees and other executive functions that is to carry, that has to go through their own screening and confirmation. And out of the abundance of frustration, he decided to ignore the need, the necessity to further repetitiously forward the list of commissioner nominees and other things, because they have the majority and they enjoy the provision of the Constitution. And so on that basis, they allege that he has perpetuated gross misconduct pursuant to section 188, sub 10 of the Constitution, that actually deprive the court, particularly sub 11, that define what gross misconduct is. But in doing that, there was procedural impropriety, there was procedural flaw. They did not satisfactorily follow the spelled out procedures from subsection 1 to subsection 9. And then when a challenge is illegal removal from, the court declined jurisdiction on the basis that, pursuant to section 10, sub 10 of section 188 of the 1999 Constitution, they are in no position to assume jurisdiction to entertain the matter. So that was the decision. And however, over the years, by the beauty of judicial activism and radicalism, the apex court, in a landmark judgment, upturned its own judgment by invoking section 6, sub 1 and sub 2 precisely of the 1999 Constitution, wherein judicial powers are vested in the courts, both courts established by the federal government and the state government, and of course, other things considered, other instruments, other bodies considered as courts. So, yeah, and determine litigations. The court also went further to establish that, by virtue of section 46, the governor, the occupier, is entitled to seek redress in the event that his right has been infringed upon. The court also went further to bring the Latin maxim, ibi jus ibi remedium, where there is in existence, in actual existence, whether in law or in equity, a right that the court will do justice. The court will ensure that it is addressed, provided there is existence of right either in law or in equity. Now, that is not enough. The court went further to say that before the Oster clause can be activated, can be invoked as to prevent the court from exercising its power, strict application, strict compliance with subsection 1 to subsection 9 of section 188 of the 1999 Constitution must be satisfied. Otherwise, any action will amount to a nullity. It will amount to nugatory. So this decision was reached in the case of Enaiku against Adeleke. Quickly, the facts of the case. In the case was against purely Rashid Ladijo of Oyo State. Now, there was political balkanization, polarization, controversy. So there was political disaffection. And a few members of the Oyo State House of Assembly went and lodged in a ridiculous hotel and then purported to come up with a notice of impeachment against Governor Rashid Ladije. When this was made, don't forget, the Constitution provides in section 188 that it is the Speaker and the persons to initiate the process are 1/3 of the entire members of and sign, and then it will be transmitted to the Speaker, not any other person, to the Speaker specifically. But in this instance case, the select few that lodge in hotel sidestepped that of the speaker and the deputy speaker. Without the speaker and the deputy speaker, they went and transmitted the notice of impeachment. They violated entirely the provisions of Section 188, sub 1 to sub 9 of the Constitution. The Supreme Court held that in virtue of the gross violation of the extant provision of the Constitution, which is expected that it should be followed mandatorily and not to be complied with substantially, but strictly. So for the Osaka clause to be activated, subsection 1 to subsection 9 must be strictly followed. The speaker was not involved, and the relevant provisions were not on that basis. The Supreme Court struck out the impeachment and, of course, reinstated the appeal, even though the court of the higher court, the court of first instance declined jurisdiction, the court of appeal assumed jurisdiction, and the Supreme Court, saw reason with the court of appeal. That was a landmark stand judgment that brought, a renewed judicial activism in the country. So I'll just pause here for further questions. Can you hear me? Can you hear me?
Yeah, can you hear me?
Yes.
Yes, I can hear you.
Yes, I was able to establish that prior to the current judgment of the Supreme Court, the court were denied jurisdiction pursuant to subsection 10 of section 188 of the 1999 Constitution. However, the Supreme Court, as in the case of Enayokuju against Adeleke, Adeleke was actually the speaker who instituted the case. Now, the Supreme Court review upturned its own judgment by invoking Section 6 of the 1999 Constitution. Another relevant constitution also pointed out that without strict compliance with the actual provision of subsection 1 to subsection 9 of Section 188 of the 1999 Constitution as amended, that it amounts to nugatory, a nullity, it's void, ab initio. In other words, it does not even exist, the process of impeachment. I think that lays a solid foundation.
Yes. Thank you very much. Thank you very much, Benson, for that very important and interesting, as well as impactful thoughts that you have just outlined there. I think that is more like that provision ousted the jurisdiction of courts from interfering in the legislative process of impeachment. However, due to current judicial activism and the judiciary relying on Section 6 as well as Section 46 of the Constitution, has decided to assert its right, especially where those process outlined in Section 188 sub 1 to 9 is not followed. If you enjoy this conversation, please do well to subscribe to the channel and also endeavor to double tap and like what you see. As a matter of fact, I forgot to mention earlier, this video will be saved for future reference, meaning that whatever have been shared here can come back again to listen to them. Thank you, Mr. Benson, for that very impactful one. Thank you. Without wasting much time, we'll go to using River State as a case study. There are some issues that have been outlined with respect to impeachment process that is ongoing. And since we are talking about impeachment, it is pertinent at this juncture for us to cross-match it with what's playing out in our dear state, River State. So my first question is, you have read the impeachment, the grounds for impeachment by the River State House of Assembly. They are outlined up to 8 grounds. I believe you have come across those grounds.
Yes. I'm very much over.
Do you, with the knowledge of the grounds, do you think any of the grounds meets the threshold for impeachment with respect to the Constitution? Do you think it is a constitutional breach that can warrant impeachment? That's my first question. Should I list the issues or you address them one after the other?
All right. So I take the first question.
Okay. Okay.
So let me take the first question. Very well. Um, there are a number of points they adumbrated as the basis for their proclivity for initiation of impeachment against Governor Simla Ifubra and his deputy, Professor Odo. First, in no particular order, of course, they made mention of the burning of the River State House of Assembly. And in law, as we know, he who alleges must prove. So that is that has not been established by them. So it's neither here nor there. Again, they said that their due legislative remuneration has not been remunerations has not been given to them. Again, they have to prove that. As a matter of fact, all the ancillary allegations they level against the governor and that of the deputy governor by association terribly has no basis. Perhaps the one that will bother our mind legally is that of budget presentation, appropriation bill turning to appropriation law, appropriation act. Let me clarify. Pursuant to Section 122 of the 1999 Constitution as amended, the governor is empowered by the Constitution to, upon the expiration of a 1-year budget appropriation law, to continue within a window of 6 months, which is half a year, before the preparation of a subsequent budget, a succeeding budget. Perhaps they need to avert their mind to Section 122 of the 1999 Constitution. Now, their lame argument that the governor is here to present 2025 budget is curious in the sense that prior to the advent of the declaration of a state of emergency, a legal state of emergency by the president, Governor Simla Ifubra was initiating the drafting of the state budget, but was caught up by the illegal declaration of state emergency by Mr. President. Having said that, when he left office, when his sole administration came on board, he continued from where the substantive and elected governor stopped and fine-tuned and concluded the 2025 budget. It transmitted the same budget to Mr. President, pursuant to the provisions of the Constitution, who, on his part, further communicated, transmitted the budget, the appropriation bill, because it has not yet become a law and act, to the National Assembly. Don't forget that any law made by a state House of Assembly is a law, while that of National Assembly is an act. So a peculiar one is established here. What we have in Rivers State is Appropriation Act, not an appropriation law, because it was enacted by the National Assembly, not by the State House of Assembly, the conformist State House of Assembly. That should be taken note of. What we have in Rivers State in existence is Appropriation Act, not appropriation law, because it was enacted into law by the National Assembly, comprising the Senate and the House of Representatives. Now, that has become a valid law. That has become a valid law. So it cannot be derogated by the State House of Assembly. They lack the power. They cannot exercise powers that are not arrogated to them, that are not donated to them by the Constitution. Again, it is not in their place to compel or coerce or persuade, otherwise compel the governor to submit appropriation budget. And the allegation that the governor is spending out of the spending out of budget is neither here nor there, because the 2025 budget is over ₦1 trillion, and they are canvassing billions. So, which means it's not even up to ₦1 trillion. And since they are still alleging, the budget is a public document, so they can assess it and then confirm whether or not it's going outside the stipulation of the Constitution.
Okay,
So
thank you
that
very
is
much.
suffice.
Thank you very much for that. That's very legal response. I would like to remind our audience that this is purely an academic discussion, and whatever we are sharing here is purely the opinion of the guests in regards to the law. We're not trying to take side in this argument. All right. So I'm aware that the governor recently, I saw on the news where the governor passed the budget to the council, executive council. I don't know which budget is that one. And secondly, we had some rumors of appointments of commissioners, to fill state commission, like the state ministry, and all of that. Haven't they raised concern within you? The constitutional provision are that the governor must pass that through the state house of assembly. What are your response to that?
Okay, again,
Just
Section
quickly.
122 of the 1999 Constitution comes into play, because the budget was caught up in eventualities. As a result of that, we are this backward. However, by virtue of Section 122 of the 1999 Constitution, the governor still has a window of 6 months, which means that he has up to now to August 2026 to prepare 2026 budget. It can continue, but what that constitution, that particular provision provides, that he cannot spend beyond the scope, beyond the provision of the antecedents or the existing 2025 budget. So all his expenditure must be within the scope of the 2025 budget.
Okay, okay. Thank you very much
Again, with
for that.
respect
But
to commissioners, whether or not you said commissioners, I suppose, the list
yes,
of
yes,
commissioner nominees. You said list of commissioner nominees. Yes,
yes.
okay.
I saw some persons who put themselves to be commissioners appointed without confirmation from the House of Assembly.
All right. First of all, um, the Honorable Attorney General and Commissioner for Justice and Commissioner for Health and a handful of others were legally confirmed by this House of Assembly. The that were not screened and confirmed by this House of Assembly. But the ones that are not screened and confirmed by this assembly, they are not back because they are not being sent to the State House of Assembly for screening and confirmation. However, the governor has the right. There is no specified period for the governor to tender list of commissioner nominees for screening and confirmation, even when there's a stipulation that he must tender. But there's no specific date fixed for the submission of such. Now, that being said, let me digress a bit. This is law mixed with politics, in that I've been privileged. I was thinking I would discuss this later, but it has to come in to see some of these pernicious conditions, harmful, very ridiculous condition they call agreement they met. First of all, the law is straight that the court cannot enforce illegality or immoral acts. It is found in the Latin expression as, okay, I'll get back to it. But the idea is right that the court cannot enforce illegal act or illegal agreement or illegal contract. Now, what do I mean by that? I will still get back to that Latin phrase. What do I mean by that? I've seen about 10 of the purported agreements, one of which is that the governor should not return for second term. Now, let me take them sequentially. Now, Section 40 of the 1999 Constitution has invested the governor as an individual, as a citizen of Nigeria, who is qualified eminently to have freedom of association and freedom of assembly and association. So he can join any political party, he can defect, and there is no restriction for him to defect. There is only a restriction for assembly member for not defecting. The only defection is valid when there is major crisis in the national level. Now that has been established, so they cannot go against the provision of the Constitution by saying
sir.
that it cannot contest. It's even contrary to Section 42 of the 1999 Constitution. That is just one aspect of it.
Okay, thank you. But before you go further on that, we still have some issues to deal with here. Like I said, after the issues, then you can look at any other issue that you feel that have arisen from these issues of impeachment from other states. You can cross match it with the provision of the law that you just discussed now. So the second issue, the second legal implication is whether the use of madam as salutation to the president. We want you to comment on that because from what we saw online, the copy that was sent that was supposedly addressed to the president, the salutation there showed Madam. However, we saw another copy that was published in dailies in the newspaper. They actually corrected that on that copy published in the newspaper. Let's say, assuming now that the said copy with Madam was sent to the governor, the question is, does it invalidate this said notice of impeachment?
Okay, very well. You know, the law is beautiful. The law does not bother about trifles. Now, there are fundamental errors and there are minor errors, or mere irregularities. It is considered by law as inadvertent error. It is also considered as innocent slip. It is considered as a curable defect. So what it means is that provided the person that is affected by the notice of impeachment is a juristic person and it's noted, but for the erroneous salutation. However, it is the panel that is set. The House of Assembly, they have no power whatsoever to, on their own, correct that which has already been transmitted. It is with the leave of the panel, and the panel has that sole discretion whether to grant the leave or not for them to correct it. Supposing the leave has not been granted, they have to start de novo. And if the leave is granted, it means that the 7 days notice can only start to commence to count upon the correction and the validation of the correction. In other words, supposing 3 or 4 days has been elapsed already, those ones are immaterial. What is material is that it will start from when it is corrected and validated by the appropriate authority, which is the panel, that will grant them leave. That is what is the position. But in actual fact, that mere irregularity, it is not a fundamental irregularity, cannot vitiate the impeachment process.
Okay, thank you, sir. Thank you for that very great legal insight that you just dropped now. Noting that they have to seek the leave of the and correct that. That's a very important point. That is what's noting. Okay, so on the third question is the legality of including the deputy in the impeachment process. So to a question was posed to the spokesperson for the Rivers State House of Assembly on constitutional weight since the deputy really have power to act most of the times in what they may be alleging. What's your opinion on that? That's the first question. I'm going to ask the second question together. Okay, or let me let you answer that one.
Okay. Let me take this one. First of all, there are two things that need to be distinguished. Now, there's pre-election matter and there's post-election matter. Now, it is during the election matter that the actions of the deputy governor or the governor can affect either of them because they are coming on a joint ticket. We have the Supreme Court case, that of the Bayelsa case, where age irregularity and sundry affected that of the governor. Now, but they are now post-election matter. So there are two individuals with the governor's functions clearly spelled out, and the constitution went further to say that to provide that the governor will, assign functions for the deputy and all of that. So it's not lawful for our deputy governor, Professor Ndu, to be guilty by association. She had to. It has to be spelled out. I mean, it cannot be too strongly emphasized that there must be specificity of an actual commission of crime that constitute gross misconduct as has been defined by sub 11 of section 188. So you cannot impute the purported gross misconduct of the governor to that of the deputy governor. Yes, the
Yes, but
constitution
to
said you can
interject,
impeach them together or you can impeach them separately or otherwise. But you cannot you cannot impeach the purported allegation of the governor to that of the deputy governor. You have to specify our own.
so what if, so
First of
permit me
all,
to
she's not,
interject.
at least they have not told us that she was in charge of the budget. They have not also told us that she was the person that entered agreement with the FCT minister, which the National Assembly, the State House of Assembly are brandishing that agreement. And I wonder what they think that their illegal agreement can override the supremacy of the Constitution. That's not possible.
Okay, that would be that for the politicians to discuss. But the issue is, what if some of the things that they are accusing her of doing is not within her powers to act, let's say constitutionally? Because I know most of the times the deputy only acts majority of times when the governor is absent, and then there are very little roles that she have to play. What would the answer be different if the things that they are accusing her of breaching, she does not have the power, like constitutionally, to act? Like some of the
Beautiful,
things, like the,
beautiful,
the entering of
beautiful.
the.
That's still boils down to specificity. So they have to specify at what material time did the deputy governor act in lieu of the governor as to warrant that the budget was at some stage, the governor had to travel somewhere and the deputy governor has to represent it in continuation of the budget. There was no point in time that was established. All through the process, the governor was involved, save for when the sole administration took over. So they have not specifically pointed out what the deputy governor did. They are merely imputing the allegation from that of the governor to that of the deputy governor, even though the governor, they have not
Thank
established anything to my knowledge.
thank you, thank you so much for this. Your very great legal insight so far. I'm enjoying this section. I believe that those who are watching, our audience, are also enjoying this section. If you're with us, please do well to subscribe. Okay, somebody incredible Joe is telling you folks. So okay, so if you're watching, do well to subscribe to the channel as well as double tap to like if you enjoy what you're watching. Moving forward, there's the last question I want to pose to you before you look at your own issues that arise. And the last question is: there's a news that dropped today, and then the the State House of Assembly members, through their spokesperson, raised a concern that the process of impeachment, their constitutional right of impeachment, is about to be threatened by a court order and interim injunction restraining them. I want you to comment on, if you look, I don't know if you saw the news, first of all. If you looked at the news, the court order that they are alleging that the governor and federal are trying to seek, according to them, so they're trying to seek a court order from the Federal High Court on their legality as members, so as to issue an order to restrain them from carrying their constitutional function. That is the first. We don't know if it's within that ambit, but we all know generally that court cannot order them to stop what the process of impeachment. Then it will depend on the grounds. You understand how the case was filed. Depend on the ground in which the case was filed. That will depend whether a court can grant an order. But impeaching now is their right. But if the matter is on, let's say, disputing whether they are legally a member of the house, then do you think an order can be granted? And if the issue is not about um, disputing their membership as the legal member of the house, do you think the order can still be granted? I would like to get your opinion on it.
Sorry, just
The legal opinion.
summarize it. I didn't quite get it. Just summarize it very quickly. Your question, I
Okay,
didn't
so
quite get it. Summarize it very quickly.
the issue on ground is there's a news that came up now. The State House of Assembly members are alleging that some persons are trying to get an order from the Federal High Court to restrain them from impeaching the governor. Now, reading through the news, I saw that I'm asking now that if the order is about the legality of their membership as members of the House of Assembly, can that order be granted to restrain them? Because we know on a normal day that it is their constitutional right and judiciary should not interfere with their statutory function. Do you understand? Do you get the question?
Yes, I do.
So if the matter in which the order is to be granted is challenging the legality of their membership of the house, can that order stand? And if it's not about the legality of their membership of the house, will the order still stand?
Okay. The the pivot to note in law is whether they have local standard to institute the suit against the State House of Assembly. That it's what will validate their litigation, their suit. Now, but if you look at the provision of Section 46, that provision is quite broad in interpretation. The provision stipulates that where a citizen of a state alleged that his right has been alleged to be affected or infringed upon by an action of the government or institution, what he like, that he has a right to approach the court to seek redress. Now, don't forget that the governor is elected by the citizen who has the sovereign power. And the citizens are, by implication, affected by the interplay of politics. So, of course, we are quite conversant with what transpired during the periodicity of the declaration of state of emergency. We are all impacted. So that essentially, except of course you want to prove that those litigators are not citizens of River State, provided they are citizens of River State who elected the governor. I mean, even the assembly members, they are subject to the citizens who exercise the sovereign power. So they can maintain an action, by way of, in fact, they can bring an action of mandamus for the court to compel them to comply with subsection 1 to subsection 9 of section 188. Take, for instance, if they try to be mischievous by bringing a fictitious chief judge, just a hypothetical situation, because they know that perhaps it's not in agreement, in alignment with them, to tinker, to utter.
I think we've lost your audio. We can't hear you.
Okay, what I'm saying, can you hear me now?
Yes, we are. I just hear that.
But I can hear you. Can you hear me?
Yeah, but not so audible as it used to be.
Okay, I can hear you. So is this fine?
Yes, we can hear you.
Okay, what I'm saying is that pursuant to section 46 of the 1999 Constitution, they have local standard in judicial, if you like, to maintain an action against them by, in fact, making mandamus, instituting mandamus against them to comply with the extant provision of the Constitution. Because otherwise than that and all of that, it can stir
Your voice
up
is not so
crisis.
audible right now.
Wow. Okay, so can you hear me?
Yes, I can hear
Am
you.
I audible enough? I'm audible enough, right?
Yes, better
Yes,
now.
Yes, I've established the fact that provided those people who have instituted an action against the River State House of Assembly from proceeding with the illegal impeachment of the governor and the deputy governor, they have local standard to maintain the case. There's no problem. And one of the
Please, for
things
those
that
in
will
the chat,
will give them.
can you hear me?
Yes, I can
I
hear
don't know
you.
if
I
it's only
wonder
me,
why you
but your
can't
voice
hear
is
me.
declining. The audibility of the voice is declining.
Okay, I guess I should be audible enough now.
Yeah.
Okay, so you can hear me. You can hear me, right? This tempo, is it okay?
Yes, I can hear you. Yeah, it's okay.
Okay, what I emphasize is that I'm yet to get the actual party who instituted the suit against the River State House of Assembly to prevent them from carrying out. Can you hear me?
I can hear you. Go on.
Okay, from carrying out their illegal impeachment. Now, this is pursuant to section
Okay.
46 of the 19. This is pursuant to section 46 of the 1999 Constitution as amended, that invests in every citizen of the state to approach the court when his right has been alleged to have been breached, to seek redress in court. So it is our rights.
Thank you very much.
All right.
We have noted that part because we are running out of time.
All right.
We are running out of time, and I think you have really addressed the issue that you raised as regards the agreement that the both parties came into, and the fact that it will not be unconstitutional if their agreement is broken or warrant, but it's rather political. The agreement is rather political than constitutional. That has been noted. Because we are running out of time, we have 2 more minutes left. I would like you to summarize your recommendation in 1 minute. What are your recommendations to the impeachment process in Nigeria? Because if you look at the book of our conversation, we're looking at impeachment. Is it a political tool or actually a constitutional power? So I would like you to give your recommendation in 1 minute while we wrap up for tonight.
All right. Very quickly, by way of recommendation, I like to
I
Establish
can't
the
hear
fact
you.
that
Can you be more audible?
can you
Or
hear
I
me
put
now?
your mic. Yes, I can hear you.
Can you hear me now?
The way you shout, I heard you. Yeah.
You can hear me now, right?
Yes, sir.
Yes. The law is that in every general rule, there is permissible and allowable exception.
All right.
Did you get that?
Yes, I get
Now,
that. I got that.
if you juxtapose that with Section 308 of the 1999 Constitution as amended, the president, the vice president, the governor, and the deputy governor, they have immunity, both civil and criminal suits. They can be arrested, they can be prosecuted during their tenure, either first tenure or double tenure. However, they can be investigated while they are serving their tenure, and it can be used against them upon the expiration of their tenure. And their offense has no expiring date. It will start to count from the expiration of their tenure. Now, in view of that, they cannot be perpetuating heinous crime, grave crime, and go scot-free. That was the reason for this constitutional safeguard of impeachment or removal, which is associated with the doctrine of separation of power and, of course, by extension, checks and balances. So the State House of Assembly is empowered by the Constitution to checkmate the excesses or the abuse of power by the governor or the deputy governor or both of them. That was why there is the provision for the removal of the governor and the deputy governor pursuant to Section 188, sub 1 to sub 9 of the 1999 Constitution. Now, that in the contemplation of the draft out of the Constitution is meant as a constitutional safeguard and not a political weaponization. But it seems currently it has become a political weaponization otherwise than a constitutional safeguard, and it is slightly unfortunate. What I will want to advise both the governor, the deputy governor, and the River State House of Assembly members is that there is no watertight, there is no strict separation of power anywhere in the world. So there's an interplay. They have to find a way to relate that, because Baron de Montesquieu, of course, somebody preceded him, when he spelled out the doctrine of separation of power, made us understand that there is no strict separation of power anywhere in the world. So they have to get a meeting point. There's some kind of interconnectivity between them. They have to relate. They have to adjust. Because what they're doing, the crisis, the upheaval in the state is affecting the citizenry of the state. That is what they have to put in consideration, and not some kind of illegal agreement. I have everything against the agreement because it is diabolic. How can the agreement, and you are brandishing that agreement? Some of the agreement are saying that a governor that is entitled to go for second tenure should not go. A governor should not nominate commissioner nominees that you will be the person. A governor should not move out of River State, contrary to Section 41. A governor should not defect, contrary to Section 40 of the Constitution. You are saying that a governor, you are going to draft a budget. FCT minister, former governor of the state.
Is Ali though?
Yes, even if it is alleged, it is in the agreement.
They are not compared to.
Yes, it is in the agreement, and that is contrary to the stipulation of the Constitution.
I just want to clarify that.
Section 121.
Thank you very much.
All right. Very well.
So we deeply want to appreciate you for the great insight you have shared with us. Your legal dexterity, me, I'm a direct beneficiary. I guess a lot of persons that have joined this meeting has benefited from the knowledge you have shared so far. It has really been an impactful one, and particular details have been laid down with respect to this impeachment process, and very important things you should note. We have really enjoyed each and every section, every idea you have shared. Thank you for making out time to share your knowledge, your depth of knowledge of constitutional law. We appreciate it. We hope to have you subsequently like this in any edition we plan in the future. Thank you so much. Just for
You're
people's
welcome.
reference,
My
this video
absolute
is
pleasure.
recorded and will be saved for persons who would like to come over to listen to it. So after 2 days from now, you can always check in to get the link for the video. Thank you so much for joining. Thank you to our audience, everyone that has liked, everyone that has commented. I see your comments. I'm really grateful. Um, we are going to close the section tonight. See you all next time.
Thank you.
Thank you, Mr. Ben, for joining.
Thank you. My absolute pleasure. Same here.
Okay.